As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel Bentv presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Happy New Year and thank you for being part of the program. Today, the program is Voice. It's your legal community education program. We'll bring you information on legal matters in the UK, information around living in the UK, doing business in the UK, studying in the UK, or having a married life in the UK in whatsoever manner it may be. You can do this successfully within the framework of the law. That is what we do on the program. On the show today, we'll be taking a look at changes expected in the 2016 legal system, and we'll be reviewing issues around what the state might likely put in place to change the law and how this may affect you in 2016. As usual, our guest on the show is the senior partner at Obaseki Solicitors, who's joined us on the program today. We'll be taking us through expected legal changes for 2016 and how this may affect you. Jennifer Obaseki is here in the studio today. Jennifer, thank you for being part of the program today.
My pleasure, and Happy New Year to you.
Yeah, Happy New Year. The whole of 2015 was spoke quite extensively about changes. The government desperation to reduce migration from its hundreds of thousands to it's just its tens of thousands, series of changes that have taken place within the immigration and the rest of it like that. 2016, what are we looking at? Are we seeing a situation where the government will continue on this path, or we're looking at a situation where the government will relax some of these immigration laws?
But the indication for 2015 and 16 is that certain fees will go up, and the requirements for those who are subject to controlled migration visas, their minimum salaries may go up. The sponsorship licenses, from the look of the consultation, sponsors who have licenses or wanted to renew, their fees will stay the same. But again, we're in the consultation period and we can expect increases usually around April, but it's not unknown for increases again to be affected later on in the year around October. Then the main issue, which has been one that's been, the main worry for many people, is the out-of-country right of appeal. We've known over the years that the reduction in one's right of appeal in country is going to come, but the way that they're going to actually enforce that quite vigorously has started to take effect. What happens now is they begin to put forward letters which outline, once your decision has been made, that you no longer have a right to stay in the country. But then this is followed up with further letters. Before, Capita was giving out these letters, a company that was contracted by the Home Office. But now these letters are coming thick and fast, and also accompanied usually with the reporting restrictions. The difference, that's happening now is the fact that, yes, they're becoming quite consistent, they're coming thick and fast. Clients are getting panicked once they see them, and they're not really knowing where they stand. If they don't have the funding to challenge the issue with regards to the right of appeal, if it's not been explained to them that they may be able to do a PAB letter, which is a pre-action letter, to say that being refused the right of appeal is against their human rights, or that decision has been issued incorrectly because they should have a right of appeal, or there hasn't been proper and substantive consideration of their application, then the clients, the applicants, tend to just panic because they see the letter, I no longer have right to stay in the country, my decision's been refused. It's not clear if I have a right of appeal, even though I've got family connections, even though this may be my second application, I put forward fresh information. So if people are in that position, they need to have a definitive answer and definitive advice on whether they have a right of appeal. The appeal form normally comes with a refusal if it's determined you have an in-country right of appeal. If you don't, then you may have to look at any other reasons that you might want to stay in the country that were not put forward with your application. Or if you feel you should have a right of appeal, you need to reply back to the Home Office upon your refusal, outlining why you think you have a right of appeal. The ultimate decision on right of appeal lies with the first tier immigration tribunal service, not necessarily with the Home Office. The law is there to guide the caseworkers at the Home Office, but they do get it wrong at times. So do seek very, very, let me say, experienced legal advice at that time. Because if it's argued successfully that you do have a right of appeal, then what would happen is you then would have to pay the £140 fee. And again, that may be subject to increase. Though I've reviewed everything before coming on air today, I haven't seen the court's indication, but even the Home Office one on the fees for applications and for visa applications has come out quite late. So there may be further increment in court fees. And after you pay the court fee, your case will be listed. And the queues, unfortunately, are long. So if you put in an appeal today, your appeal hearing date may be some 5 months away, which is a long period of time for anybody to feel anxious, worried about what their ultimate fate could be. So unfortunately, the answer to your question is the momentum is thick and fast. It's not changing. It hasn't quelled in any way. If anything, it's been reinforced by these increased fees, by the regimented appeal system that's been put in place. So people do have to be all the more wary about their situation, and even more importantly, you have to be prepared. You have to be prepared for the fees that are required when you're renewing your papers or applying for indefinite leave or naturalisation, because if you allow yourself to become an overstayer, it makes you in such an adverse position that it's hard to recover from that position. To say you don't have enough money, that's why you didn't renew your papers on time, is not a very good excuse, not a good explanation. You may lose your in-country right of appeal if you allow that to happen to yourself. So more than ever, it's important for you to prepare way before your leave expires. Start saving the money, start preparing your evidence so that you can put your application for an extension in good time, please.
Okay, let's go to housing matter. Of course, we do know that almost every year there's always an increment in stamp duty. Are we likely to have an increment in stamp duty in 2016? If we do, what will be the implication for first-time buyer or people who are already trying to pay mortgage or resell their house or the mortgage or stuff like that? And then let's look at residency test for tenants. Government has been banned right now around the issue of tenants having their status confirmed before an agent can give them a house. So will government still be going ahead with our change? And if that does happen, what will be the impact on the community, on especially the ethnic minority community, on residency test for tenants? For start, let's look at stamp duty.
Well, with regards to stamp duty, in April there is going to be an increment in stamp duty. It has been quite consistent for some time, but in the last budget there was the announcement that there's going to be an increase with regards to the threshold, and also an increase with regards to people who own second properties. Now, the way that this is calculated is not very straightforward, but if you have a second property, the amount of stamp duty you will pay when you're registering it is going to increase somewhat. So you do need to get some advice. Many people are rushing to buy property before this increase comes in April. So if you are trying to expedite a conveyancing transaction to avoid this, then make sure you do negotiate let's say the time scales, and explain in your instructions to your solicitor what you're trying to do, so that the solicitor can make sure that the conveyance is done in a timely fashion. All searches, etc., will need to be expedited and come back in, especially local authority searches, etc., can take some time. And it's important again that you do take some financial advice when it comes down to talking about taxation, financial implications. A lawyer can advise you on what the law is and when certain new legislation is coming in. But when it comes down to your financial advice, make sure you either go to a solicitor that is, let me say, registered with the Financial Services Agency to advise you on your financial decision making, or that the solicitor then seeks advice from an accountant to advise you thoroughly on the financial decisions that are impacted in your legal instructions. It's important again that you realise that whoever does give you that advice should be insured, should be qualified. So make sure they're registered with the FSA. Make sure that they have insurance to cover the advice they're giving you. Because if you make the wrong decision and then you realise that your tax burden, either through stamp duty or through other words, capital gains tax, or from any other financial sanction, is going to be more than what you anticipated. If it was, you thought you were trying to reduce your liability and somehow it wasn't reduced enough, you're still going to have to pay it. It's a matter of whether somebody is going to be liable for the advice that was inaccurately given to you. With regards to the issue of identifying tenants, knowing whether they have residency documents before you can issue them with a tenancy agreement. Yes, the government was supposed to roll this out much faster. They were supposed to create a portal in which you can check on the .gov website whether the person that you're letting the property to, if they're subject to immigration control, has proper leave to remain to be in the country. The portal did not get developed as fast as the Home Office really wanted. The pilot scheme was launched in Birmingham, so they also realised that there were some tweaking problems that they needed to sort out before they rolled it out nationally. However, this is still set to be in place, and actually landlords should be identifying who is in their property now, since it's something that has been rolled into legislation. If the implications of the sanctions, if you fail to do so, are there, again, financial implications, so you have to be very, very wary and follow the correct guidelines with regards to this. One of the things you may want to do as a landlord is to contract that element out. So if you instruct a managing agent, or if you instruct, let me say, solicitors to diligently check the ID of those whom you are renting your property to, then you have basically taken steps to make sure that you have complied with the legislation or delegated that out to a third party. If you can show that you've done that, then if there is a mistake, then obviously it should not reflect back to you because you have diligently delegated it. But again, there should be, let me say, care taken with regards to this. One of the things in the ethnic community, as you say, is a problem of, let me say, houses being in multiple occupation, renting room to room to room to room. The fear is when you bring in legislation like this on landlords, that the ones that will not comply with the legislation may become unscrupulous, start to put, let me say, their houses into houses of multiple occupation, because those who are not able to comply and provide documents to the tenants that cannot provide the documents are likely to have to go to less good quality housing, so substandard housing. And as rents are, even as they are, people are finding it difficult to rent houses and flats in their entirety. And you find that families are renting rooms, and that puts children at risk, that puts themselves at risk because of the health concerns. It leads to other disrepair issues. So as a community, it's quite, let me say, a concerning thing, a very concerning thing, because already there's a shortage of accommodation, it's expensive, and then those people who can't even afford what is of average quality out there will be forced into substandard housing. So landlords have to be careful, not put under emotional pressure, and families as well. If you are in a situation where you're facing homelessness with a child, whether you have papers or not, it's important to know that you can go to your local authority to ask for help. They must do an assessment of the risk of harm to your children. If that means that you should get assistance with housing, it should be given to you, because no child in any borough is allowed to go homeless. The downside of that is, though, if you are subject to immigration control or you have no recourse to public funds, then the suggestions that may be put forward to you by social services may be unpalatable, i.e. separation of yourself from your children. Your children, since they are subject to protection, will be entitled to housing under the Children Act. So therefore they may accommodate the children if they see that you as an adult are not at such serious risk and may be able to lean on your contacts within the community, that you've done so for some time over the years that you've been even undocumented. So that is the worst case scenario, and I must say it is rare for it to happen, but it's a threat that is often given out by the local community, the local social services and children and family services, that there could be separation if you're definitely homeless. The other thing is, they may say, since you're subject to immigration control or you've been refused in the past, you should go back to your country. And if you have no application pending, that may be something again that is offered to you as a family if you're homeless. But the law on housing has become very, very tight, and it continues to be, let me say, upheld by the courts of appeal, that the test for being not just homeless but then vulnerable and in priority need, the threshold has gone up. We are seeing disabled people being told they're not in priority need. So talk less of if you're not documented, it's very, very difficult. But again, go to a housing specialist if you find yourself homeless. The laws within housing, not just on being homeless, but also with regards to, let me say, being destitute and begging, have even been more stringently worded and drafted. So it makes it difficult for people who are homeless and, let's say, on the street to remain in one place. Such is it now that you must present evidence of your priority need and why you as an individual are not able to obtain properly a property or a place to live as would the common man. So even if you're disabled, you would have to show why, with your disability, it is unreasonable for you to expect to look for accommodation on your own, or why you don't have the resources. The disability alone does not qualify you. So you have to show why it is additionally difficult or impossible for you to find accommodation with the disability. The disability alone is not sufficient evidence for you to be considered to be in priority need.
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors, we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
All right, Jennifer, given these changes, what advice would you have for my viewers as we get through to 2016?
The advice to the viewers is please prepare yourselves for the financial increase on the application of the immigration applications. Save, get advice, in good time. Don't wait till 1 month before your papers expire. Start at least a good 6 months beforehand, because you may have to save up, because each application, the NHS fee, the Home Office fee, takes you over £1,000, and that's not even taking into consideration legal costs. There are no fee exemptions if you're working part-time. The whole idea is to force you into a decision where you may have to go back home or into a position as an overstayer if you're not prepared. So don't let that happen to you. Start in good time. The other thing is, if you're a landlord, please be aware of the fact that if you have more than one property and you're continuing to buy, you are going to have to pay the increase in stamp duty. You also are going to have to think about who is managing your property portfolio, so that you meet the government requirements to check the nationality and identity of your tenants. Make sure you review your files, your existing tenants, to make sure that you again are compliant with the law. If you are a tenant and you're in a position where you're not documented, you may need to make an application or get further guarantors before you rent a property. If you have children and you're finding it very hard, or you're facing homelessness, you must be confident enough to go to your local social services department to seek assistance. No child in any borough is allowed to remain homeless. And then finally, prepare yourself. Everybody is different. You must be able to get proper legal or proper financial advice from a qualified solicitor, from a qualified accountant or tax advisor. So very, very important. Make sure that you are not just meeting people whose sisters, brothers, mothers studied law or studied accountancy and get advice. Get proper advice in line with these government changes. 2016 will be your year if you prepare.
Okay. 2016 will be your year if you do prepare. Right, this is how far we can go on the program this week on Voice, where we've been giving you information on how you can live within the scope of the law as a member of our community. If you do require further information, you can get in touch with us via the phone number on your screen, or you can follow me on Twitter at Tunde C3 at Tunde C3. That's my Twitter handle. You can just practically call Bentv, or call Jennifer or Basiki, or Google Jennifer or Basiki, or send an email or text message to the number on your screen. This is how we can go on this program. Thank you for being part of the program. I'm Tunde Alabi. Until we come your way again, stay out of trouble. Bye.
As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts, and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel Bentv presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.